Hello and welcome to the third episode of TLJT Talks. Today we have with us Mr. Yash Bajaj. Yash is currently pursuing his LLM from NYU School of Law in International Business Regulation, Litigation and Arbitration. Prior to going to NYU School of Law, Yash has worked with Parinam Law Associates in their securities department for a term of almost 2 years. So thank you, Yash, for joining us in this podcast today.
Thank you, Ariman, for having me, and congratulations on this fantastic initiative.
Thanks. So today we are going to discuss crimes in cyber world. I'll start by asking you a simple question. How would you explain the meaning of crime and its relation to cyber world?
So, crime is something we've always seen under the Indian Penal Code. It's been, there's a whole statute that basically defines the various sort of crimes. But when it comes to cyber crimes, there has not been any definition, any statute or rule book. So cyber is actually a slang for anything that is used in computers, information technology, the internet, virtual reality. So basically anything related to the computer, what actually can constitute an electronic record or not is very important from the Information Technology Act point of view. And there is also a little conflict between the IT Act and the IPC sometimes. There's also a harmonization of the two statutes which needs to be looked at and which needs to be touched upon by India very importantly in order to basically constitute offenses under these acts, in my opinion.
Right. So you talked of IT laws and IPCs. My next question is
Yes.
in relation to that. So with the advent of internet over the past 2 or 3 decades, I think some new kind of crimes are coming up. Cyber crime or cyber bullying or stalking and these kind of things.
Yeah.
These were unheard of
Correct.
like some 20, 25, or even 15 years ago. So
Absolutely.
and we have seen that people ranging from a common man to most influential people, all of them get affected by this uh, crime in cyber world. So so
Correct.
so keeping in mind the purpose of criminal law and IT Act, how do you think, what is the relevance of IPC with respect to the IT Act? How can both be interlinked?
I think this is very important because whenever a charge sheet has actually come up, like, whenever a police officer is finalizing the charges also in the FIR, and then later when the court basically adjudicates upon the charge sheet, what happens is that a lot of sections of the IPC and the IT Act are within the same charge sheet. So a lot of these sections are interlinked. For example, now with respect to hacking and data theft that happens through the computer, there are sections 43 and 66 of the IT Act. But also at the same time, I would say section 378 of the IPC applies because then theft relates to movable property. Now, what the counter argument is that whether data and whether all of these things constitute as movable property or not. So now, what the courts have construed sections 378 to be, and they have categorically stated that movable property are intended to include corporeal property of every description, except for land and things fastened and attached to the land or permanently fastened to anything which is attached to the earth. Now, obviously, the maximum punishment for theft is up to 3 years or a fine or both. So the counter argument made that, like, corporeal, which means physical or material, would exclude digital properties from the ambit of section 378 has now become an ill-founded argument. And therefore, the courts, this is a settled position of law, in my opinion. Now, you also have section 424 of the IPC, which talks about dishonesty and fraudulently concealing or removing any property of himself, which would also apply to such sort of crimes. You have section 66B of the IT Act, which speaks about the receipt of stolen property. Then you have section 425. So in conclusion, there are a number of sections that take care of all of these things from the IPC and the IT Act, and the charges that are basically leveled against the person in the charge sheet would include sections from both of these statutes. But now there is what becomes important to note is when there is a conflict between the IPC and the IT Act. So in this judgment of Sharat Babu Digumarti versus the government of NCT Delhi, this conflict basically came to light, and the facts were such that there was an obscene video that had been listed for sale on a website called bazi.com. Now, out here, the mistake that was made, and I find this quite absurd, but the mistake that was made in this entire in by the police out here, that Bazi, being a separate legal entity, was not made an accused, whereas the director, the managing director, and the CEO were made the accused in this particular judgment. Now, what has happened is, because of the mere fact that the company Bazi was not arraigned as an accused, this helped the director get off the hook, because vicarious liability could not be fastened, which I find pretty absurd, because it should not depend whether a person has been made an accused or not. Vicarious liability is something that always prevails. And there are concepts like, in SEBI laws also that we've dealt with under section 24 of the SEBI Act, where you lift the corporate veil and who is in charge and responsible of the company. So the words in charge and responsible become very important. And I think the courts must exercise their jurisdiction and their powers to basically make sure that that these provisions are given the effect that the legislature intended. Now, out here, the Supreme Court unfortunately quashed the proceedings against Sarat Degumarti, who was the managing director of Bazi, just on the fact of vicarious liability, and also the fact that the IT Act is a special enactment as opposed to the IPC, which is a general enactment. So the fact that remained was, because the IT Act section or the charge was dropped against the accused in this matter, they said that the IPC charge also goes away, because by virtue of a special enactment provision moving away, the general enactment got taken away, which is again something that I don't agree with entirely, because it should be its own separate proceeding in itself. And in criminal law, especially under the IPC, it depends on whether the ingredients have been fulfilled under each section. So in my opinion, if the ingredients are fulfilled, even if the IT Act provision were dropped, this should basically continue and have its own set of adjudication, which was unfortunately not done. Now, you've seen many other cases like Gagan Harsh Sharma versus State of Maharashtra, where they were accused of data and software from their software theft from their employer. These all things happen under 408, 420 of the IPC. They all basically, 420 is the most famous provision under the IPC. Everything comes under 420, cheating. Then you have also sections, or like sections 43, 65, 66 of the IT Act also, which were there in this particular matter. And it was held that section 408, which deals with criminal breach of trust by the clerk, states that whoever, being a clerk or servant employed in any manner, and is entrusted with the capacity of this property and has dominion over this property. So these are the ingredients, basically, commits a criminal breach of trust in respect of that property and shall be punished for whatever number of years is mentioned under the section. So out here, basically, the accused had faced justice, and they were basically held to be guilty, and that's what happened. So in my opinion, when it comes to the IPC and the IT law conflict, of course, I do agree with the fact that the IT law is a special enactment. I do agree that, okay, when it comes to basically giving punishment or inflicting punishment, then a special enactment needs to be looked over a general enactment like the IPC. But as a matter of fact, when you are basically adjudicating a matter, just by mere fact that the IT charge has been dropped against you, that should not be the reason why an IPC charge cannot proceed. That's my submission. So the conflict needs to be taken care of more delicately. And of course, if anybody just goes and has a look at the provisions, what has happened is that the IPC, there have been several amendments to the IPC over the years, wherein a lot of things that have been defined under the IT Act have been construed to already be a part of the IPC in this manner or not. And when it was not expressly stated, then there have been amendments to basically explain it. And the intent of the legislature comes out very clearly in such a case. So sorry for the long answer, but that's my analysis.
Yeah, so you substantiated it very well with the help of case laws and all these things. So before we move forward, your question came to my mind. You talked about corporate will, the upliftment of corporate will and vicarious liability. So if suppose there's an employee who uses the server of his or her office or firm to commit a cyber crime.
Yes.
Then
Yes.
in that case, this question is from a very layman perspective. Like if I work for you, you're my employer, and from your server I commit some crime, I do some wrong, then then will that will be uplifted and the liability will fall on you, or like what will happen?
Correct. So there, of course, vicarious liability and the principle of agency as defined under contractual law will also apply, because what becomes important out there was whether the principle manifested such a thing or not. Now, the thing is, if I'm doing it to cheat my own employer, then obviously the employer is not going to be held liable for my acts because it was done behind my back. But what if I was doing it for any other purpose, which I don't see coming up in this particular case? But like, for example, if let me come up with another hypothetical. Say, for example, if my employer has instructed me to go and to basically hack my competitor's computer and get out all trade secrets or any confidential information that they may have, like, with pertinence to their business. What happens is out there, if I do that, then that would bind my principle. So that's how vicarious liability would work. But if there is a charge against me that I'm cheating my own employer, then of course vicarious liability cannot be fastened upon my employer.
Right. So the question I asked might come to the mind of all the law students, because most of us have seen Suits, and in season 9 there is an
Of
instance
course.
when a person is instated from bar into that firm, and she's there to look after the function of the firm, and then the managing partner uses the IT department to hack into the bar server and all these things. So it just came from there.
No, absolutely. That's a good example. And yeah, I mean, that happened, in Suits when Harvey basically let Mike into the firm, they hacked into the bar. So again, if the bar brings an action, it would basically bind Harvey. That's what exactly I was saying. And the IT department and the firm would be under severe action. But yeah, but I mean, if Mike did this without Harvey's knowledge, and then obviously that would not bind Harvey unless otherwise shown. So yeah, it's a very gray area, and it obviously depends upon, it's circumstantial on every case.
Right. Right. So over the years, we have seen that cybercrime, obviously, as we spoke, has been increasing in the past 2 or 3 decades, like we
Yeah.
already talked about. So mostly cybercrime is committed to do a fraud, but 60.2% time cybercrime is committed to do a fraud. But the second and third most sort of the crime is cyberbullying or stalking and sexual harassment. So
Yeah.
what laws do you think, in your opinion, in IPC, IT Act, or wherever, protect people from these kind of instances like cyber hate, cyberbullying, stalking? And do you think the laws are enough?
So cyberbullying is basically it's something that has just come up recently, and I mean, of course, I mean, it's been an inherent part, but because artificial intelligence and technology is moving extremely fast, I think the legislative lawmakers should also basically adapt to these situations, and then they should come up with laws that will basically, because so much is happening in terms of artificial intelligence and technology. I think there should be proactiveness on part of the legislative people. I think that a lot can be done. And what happens is that I mean, obviously the law could not foresee technology going at such a fast rate. So to now basically come up with certain instances of, like, cyberbullying, etc., and to apply the relevant provisions of the IPC or the IT Act to instances which have not been foreseen by the lawmakers themselves, that becomes absurd, and the purpose is lost. So of course, a lot can be done in terms of coming up with new laws to dealing with these situations. As a matter of fact, I was working on an algo trading scam when it comes to securities, maybe a little off topic. But the problem is that, like, there were no proper, the entire crux of the matter was that there were no proper guidelines, no proper laws or rules or any ordinance when it came, even norms when it came to handling of this entire software. So as defending one of the appellants out there, the brokers, this was our major argument, that in absence of guidelines, and we took advantage of it completely, that in the absence of guidelines, you cannot apply SEBI provisions or NSE provisions to basically a type of architecture which you yourselves are using for the first time. So this needs to be done at an extremely important pace. Now, what exactly? I mean, there are so many things that are coming up about cyberbullying, cyber stalking. So both basically both relate to cyber harassment, and the difference is that the age of the offender or the perpetrator of the crime. So cyberbullying or anti-bullying is an offense which is done by the adolescent, but when the same is done by a major, it is known as cyber stalking. That's the only difference. So it's just basically the age. Now, whether you go under Juvenile Justice Act or whether you go under this particular sort of legislation, it's a different thing altogether. But that's the only difference exactly.
Right.
So as I was saying, cyberbullying and cyber stalking, the differences between the age of the offender. Now, what happens is that, of course, it's done in so many ways today that we can't even fathom. But when it comes to what sections at the moment can be applied to basically book a person under cyberbullying or cyber stalking, you have section 292A of the Indian Penal Code, which basically talks about printing, selling, advertising grossly indecent pictures, any blackmail, whatever is done. And then section 354, which defines sexual harassment and the punishment for sexual harassment. You also have the Prevention of Sexual Harassment at a Workplace Act, which has come in now. So, I mean, a lot of things could be done. I mean, people send in appropriate emails. Bosses may basically, through all of, I mean, platforms, electronic record platforms, there have been many instances, and this happens a lot, where they may basically exert their authority and then they may just send these emails out and so, I mean, all of this can also be taken care under the Prevention of Sexual Harassment at a Workplace Act. Then you also have section 354C, wherein a cyberbully can be punished for taking pictures and be held liable under this particular section. Then 354D becomes important because you stalk the monitors and also I mean, you hack into a woman's internet portal, or you hack into a phone or any other form of electronic communication. And there are a lot of, I mean, there you have section 500 for defamation, email abuse, 499, 503 of the IPC. And you have your IT Act sections, which are again the same, be it section 66 for identity theft, be it section 66 E for the punishment for violation of privacy. Again, that may happen in the case of a woman or any other sort of harassment. And also section 67B is important for publishing or transmitting such material, which may also depict children in sexually explicit acts in the electronic form. And you have, I mean, a basic section or section 72, which deals with the breach of confidentiality and privacy. So that should answer your question.
Right. So you spoke about many sections. I think some lawyer can listen to it and go to court and directly present the case. But you know,
Right.
you spoke about children, you spoke about working women or the employees and these kind of people. So they are the ones that don't indulge into litigation, legislation, and the books, like whatever is written in law and all these things. But if government comes with a guideline or something, because we are a witness to it that majority of cases of these kind in India goes unreported, and
Yeah.
you threw light on modes and manners of commission of cybercrime. So do you think what do you think government can do in terms of providing a guideline for protecting people from cyberbullying, and where all can it improve and make the provisions better? How can they reach to the common man, to one who can be a victim to these crimes?
Sure. So as I had mentioned previously also, what the government needs to do best is adapt. Cyber bullying, cyber stalking is moving at a faster pace than we can imagine. And if the lawmakers and if the legislature does not act effectively, then it can just get much larger before it can be contained. And when these matters then come before the judiciary for interpretation of these sections, what we don't realize is that these sections are also, I mean, quite specific. They cannot be construed in the most widest sense, because then it may hamper judicial precedent for the other cases, which are already in existence. So you must also construe them in a narrow way possible. Therefore, for things to be construed in a wider way, or to bring new issues or new developments to cyber stalking, cyber bullying, which may basically come up, what needs to be looked at is how foresight is very important. How a person may basically do these things with new technology available, with new artificial intelligence coming into place, and then to think about what laws can be done to prevent this. That's how the government should act proactively. because everything is moving online. Everything. I mean, today with the whole coronavirus situation, Zoom has become so huge. And I mean, since everything is on the internet today, um, even courts are basically virtual. People need to understand that there needs to be a set of rules, a set of guidelines that needs to come up on how to basically safely and effectively use these portals, and how to basically think from the mind of a criminal, like what can happen. So obviously, I mean, the foresight is very important when it comes to enacting any criminal enactments, or just to understand what may happen, and from the perspective of a criminal, how he may act, so that those, if new rules, if new regulations come up, then all of these new crimes can basically be attracted by those provisions. That's how the government can also act. Also, you mentioned something about the common man does not want to take proactive steps. Also, I would say that yeah, a lot of people may be shy, like in the office also they may be privy to such harassment. But I mean, awareness is important in that sense, to basically urge them to come up, not to remain silent, even if they are facing any sort of discriminatory action. There is a good form of redress that is there now under several statutes. Even there is a Protection of Children from Sexual Offences Act. In fact, that act works from the perspective of French law. It is not innocent until proven guilty. It is guilty until proven innocent. So people should take advantage of these situations. You cannot enter a not guilty plea. The burden lies on the person to show as to why he is not guilty in such an offense, which is French law, exactly, French criminal law. So people should take advantage of this. They should not sit silent. And when you have a good system of redress, I would say the judiciary, obviously, there are many prevailing problems in terms of speed, not fast adjudication, etc., and delays. But these are things that needs to be solved on a larger scale. But when it comes to these things, I think people should exercise the right to redress more effectively and understand the law, because ignorance of law cannot be pleaded.
Right, ignorance of law is an excuse. So you rightly said that we need to get into the minds of criminals first to make perfect guidelines, right?
Only in the minds of criminals, that's all.
Right.
And just for the purpose of guidelines. So yeah.
Right. So and you said that during the time of COVID, everything has gone online, and there's a survey by there is a report by NCRB that says that cybercrime has increased from 3.3% to 3.6% from 2019 to 2020. And there is one more report from Microsoft that says that India ranks 3 in the number of online bullying cases reported. So what do you think can be a reason for this? Could education, could sensitization, could making people more aware of it help us overcome it?
So what I suggest out here is that awareness is very, very important. People are very gullible in our country. Also, the illiteracy rate is very high. People don't know how to basically, people don't know how a system works. They may get scared, and then they use the internet for wrong things, and then they may feel scared because they don't understand what the right to privacy is. They don't understand the IT Act. They don't understand the Indian Penal Code. I actually do appreciate the fact that, like, some institutions, many schools are coming up with anti-ragging. At least, this brings up some sort of information. People may take it very lightly and delicately when they are in college in terms of what they are signing. Because, I mean, as lawyers, we basically have a tendency to read through everything, why these forms are in place. It's good that the government has basically come up with this initiative wherein all the boards have to mandatorily take this up, make every student sign all these anti-ragging things, because now it doesn't only happen in school bullying. As we know, it's all cyber. People may basically just make fun. They may just, like, make memes of a person, derogate him in any possible manner. People should understand what defamation is and exercise their right to redress. I think there needs to be an emergence of awareness in this area. That's the only way, basically. And also literacy. I mean, that's a problem that, I mean, awareness would also help in solving this issue. For example, if a person is feeling messed up, like if he is a victim to so many of these crimes, he should be able to go to a police officer who should be able to explain to him the provisions and what his how he can effectively address his right to redress. And therefore, it's not only awareness when it comes to the population at large. I would say that, like, the law enforcing officers need to basically be aware of the sections themselves, the powers that the statute basically casts upon them. to enforce and effectively enforce these provisions, and just to make the general public more comfortable in terms of taking action. So it's when the law enforcement officers, which unfortunately in India, they don't understand the law as much, like, the extent of the law, the might of the law. So I think awareness to them also would help in further dealing with these issues, and seminars that can be held for them, probably, like, on all of these things, because I don't think like many of our police officers are equipped with knowledge, with information on how these things work. I had a matter actually when I was working. I unfortunately, obviously, I'm bound by privilege, so I can't discuss names. But what it was very interesting because there was this one celebrity who had gone to Austria, and what had happened out there was that maybe he had apparently, allegedly, had an affair, and that lady out there was actually threatening to put up pictures and put a website of him up. Now he lives in Mumbai, but he had just gone to Austria. So obviously the point that came up was jurisdiction. And but there was no answer as to what needs to happen. So the only possible thing was settlement, because this is not covered under international. I specialize in arbitration, commercial arbitration, treaty arbitration, security. So I have never come across a matter like this. Gladly and thankfully, it got settled. But what happens in such a situation of jurisdiction is also important, because it's not only restricted to your country. So maybe some sort of treaties need to come up with other countries wherein these issues are addressed largely. And I think the global community should look at cyberbullying and cyber stalking and what happens in the event that an international dispute does arise. So that's also important to know, because jurisdiction became an important point of research in that particular matter.
Right. So just a simple question here. Do you think that too many laws complicate the path to justice? Like in India, we have so many laws. Even lawyers get confused at times that, which law to apply, which not to apply. We as law students, we have to, dive into laws like so deep that we merely find some relevant laws for moot courts and all these things after a day or 2 days of research. We are just finding one law or two case laws or things like that. So it's us. So do you think that too many laws complicate the path to justice for a common man, or his or her understanding?
In a sense,
yeah.
Sorry, please complete your question.
Yeah, go on. That's it.
Sure. So I do think that in certain cases it does, but I also think behind every piece of legislation there is an intent, which is very important to understand the intent. Before you move and start reading a statute, it is important to read the preamble. It is important to know where the legislature or where the lawmaker is basically coming from. And that needs to be looked at immensely. But I do agree with you largely. I was working on this one Admiralty matter. It was a liquidation of an Admiralty company. And liquidations are normally obviously taken care of by the NCLT under the IBC right now. So what happened was, whether the IBC prevails or the Admiralty Act has precedence, and we obviously wanted the Admiralty Act to apply because we are representing a port, and by virtue of the Admiralty Act, I would be one of the first people paid under the scheme of when the company is being liquidated, as opposed to the IBC, where I would fall under and operate under a non-secured creditor, and I probably would not get the money or and I would face a lot of problems out there. So what happened was, there was this judgment which came up by Justice Sriram, where he harmonized the Admiralty Act and the IBC, which is very important and which helps in basically construing statutes better. So the entire principle of harmonization, the doctrine, needs to be looked at extremely importantly when there may be many laws. Of course, the Admiralty Act is a more specific enactment when it comes to the IBC, because the IBC, what happens, it deals with all companies, any and all companies. But Admiralty Act deals with specifically shipping and shipping companies and ports and this and that. So there was a whole argument about special versus general, which is also important to answer your question on when there are too many laws which to apply, because then in such a case, special enactments would take precedence over general enactment. If there are two special enactments, the date on which the special enactment had basically been enacted becomes of relevance, because then also then you have to look at the non-obstante clause, which is notwithstanding anything contained in any other law enforced or anything contained within this particular act. So the non-obstante clause becomes very important to look at in these cases. So a couple of things are there which need to be looked at, and then you have to see how courts may have construed them in other matters, because this is a thing which is not very specific to only cyberbullying or this. It's basically which act applies. So to answer your question, there are a couple of factors which needs to be looked at. There was another judgment of Damji Walji, wherein there was a whole an LIC Act and against a more general enactment. So they basically gave precedence for the LIC Act. So again, special versus general, all of these factors become very important in understanding choice of law, intent. So I hope that answers your question in terms of which law.
So I'm sorry I'm sticking to this question for so long, but you know, just the questions keep coming in the back of my head when you speak.
I can imagine.
Yeah. So you talked of intent, right? This thing just hit me that, you know, most of the colleges or schools, they have this meme page. Like every college has its meme page or confessions page or these things. So, and you know, pictures of the students and faculty and all these are posted on these pages. So do you think it defames them, or it can amount to cyberbullying?
That's a delicate area. It depends. Firstly, if I think the degree of such thing, the degree of the statements that are made are very important. Now, if it pushes a line, obviously, then there are grounds to sue. Then it can possibly amount to defamation, and whether criminal defamation, whether civil, that depends. But I mean, I also motive. In criminal law, what's important is obviously mens rea and actus reus, right? So obviously motive, which is very important as to why a person would want to do such a thing. Is it also just done right now? Like, you know, is it done on a regular basis? Is it done with a particular thing in mind? Like, you know, is there a personal vendetta against the person? So all of this is very factual and circumstantially based. That becomes very important to understand the intent behind why this entire thing has been done. Now, this whole WhatsApp privacy laws were being argued before several high courts, and what was held was, I mean, how can an admin of a group be responsible for what the other people on the group send to that particular other members of the group send to that group? So, I mean, the law is developing in terms of precedent. There are common law jurisdictions, so precedent is everything, and let's see how the courts keep moving on these matters that can basically fill up all these areas and lacunas. So maybe if I haven't looked this up, but honestly, if you could find some sort of a judgment where this could have happened earlier, so that would basically help answer your question also. But it all depends on what matters actually end up going to court, and whether this could amount to basically cyberbullying or not is again a gray area. So
right. So I'll just move to next question, because, you know, question keep coming in the back of my head. I still have
absolutely
questions. Okay, so most of these meme pages, they have this that tagline that you say that this page is for fun purposes only. Don't take anything seriously. If you want anything to get removed, just DM us or something. But what if my meme is made and I see it after a day, and by then it has some 1,000 or 1,200 views or shares, and it's all over WhatsApp and in, you know, people's phone and everywhere. So how am I protected then?
Even stockbrokers or mutual funds, they have that. Remember that tagline that they have,
subjected to market risks.
Yeah, market risks and this and that. That doesn't mean that SEBI cannot basically proceed against mutual funds. That doesn't mean that unit holders of a mutual fund cannot proceed against them. We still move to arbitration before the NSE. So just by merely putting a disclaimer on your page and doing something with a vendetta in mind should not prevent you to, I mean, I can put up a disclaimer and do my own thing, like, you know, which may circumvent the disclaimer in itself. So that should not be a ground, in my opinion, to basically prevent any sort of action. And the courts will obviously look at it from a larger perspective. So yes.
Right. Okay. Thanks, Yash, for drawing a perfect analogy of a stockbroking and these meme page. They made a lot of sense.
Yeah, not at all.
Yeah. So let's move on to our next question, and so we'll sit all night talking on these things only. Sure. Section, you talked about a lot of sections and provisions of laws. Section 354D of IPC deals with the stalking of women. right, on the internet.
Yes.
So do you
Yes.
think, yeah? So do you think this provision should be made more gender inclusive? Why only women are protected? Why not men?
I agree with you. I think it definitely should be made more gender inclusive. Um, of course, unfortunately, in our country, a lot of women have been victims to cyber stalking. Of course, there's no doubt about that, and this provision does provide a lot of, I mean, a lot of, it helps as an aid to women to take, effective action, of course. And I mean, cyber stalking of men is also becoming a more prevalent thing that is coming up. So obviously 354D of the IPC will not apply out there. Now let me just answer this with a hypothetical that I had actually come up with. Suppose, say, Mr. A is the manager of a venture capital fund, and he's been stalked online by another individual, by say Mr. X, who may be a male or a female. So let's say that it's a female, or Mrs. X. So now Miss X had initially sent a polite email to Mr. A that on his work email address, that I really want to seek an appointment for a job, and could I make an investment pitch, and I could also tell you about my startup. This is what Miss X is telling Mr. A. Now, Mr. A said that I think I'm fully staffed at the moment. There are no vacancies. Please reach back to me. I'll reach, leave me with your email address, and I'll reach back to you whenever there's a vacancy that arises. And there was basically just politely declined the meeting. And now Miss X has gotten angry. And what she's basically doing is that she is sending, making memes of this guy. She is passing derogatory remarks and so many things, right, about this guy. Now, obviously, what is Mr. A's recourse in such a case? So obviously, he can look at criminal intimidation under 503 of the IPC. He may also move to defamation under 500 of the IPC, which may tantamount to 2 years or a fine, etc., etc. But then again, what comes coming rightly to your question, I mean, what effective redress does he have in such a case? What 354D gives to a woman? He does not have that redress. Of course, he'll have to look at other sections of the IPC, and he may lose the trial because to fit his case into these ingredients may become hard. And that's where the entire gray area comes up. So of course, it needs to be made gender inclusive. Other things are being done. And why should he not be able to seek recourse to a specific provision when and to other gender provisions? And why should he have to fit his case under those particular sections when, I mean, there is a perfectly good section 354D, and it could be made more gender inclusive. So he could basically easily fit his case to that particular section, be able to prove it in court, get speedy justice, because it could be an open and shut book case. But here he has to go through 10,000 other hassles to basically seek secure justice. So in my opinion, definitely gender inclusive becomes very important, especially with all that's happening in India, with basically the gay rights also basically coming up. There can be a lot of instances where this happen, where a particular gay man may also basically be privy to or be victim to a lot of these activities, and from his partner, maybe not from his partner. So what happens in such a case is that he should be able to, I mean, if a gay man is being stalked, what about his rights by another gay person? So since other laws are being given so much importance to, and that's basically being settled, I think there should be a section that comes up here. Not being crass, but I think he should be effectively be able to basically seek secure proper redress. Such a thing.
Right. So from whatever you said, I can draw that there is no specific legislation regarding cyberbullying in India, but there are scattered provisions like Section 67, or you talked of 500, 504, or 507 of TPC. So and as you indicated, they are not enough to tackle the problem, right? So what is your viewpoint on that? Should there be a specific law on cyberbullying, cyber stalking, and these things, or guidelines only could work on, or incorporating few sections or clauses with regard to these in IPC or IT Act or at other places can help? Like, what is your viewpoint on this?
I would say amending the act. I mean, there have been amendments to the IPC also with all these sections. With cyber stalking was not always in the IPC. It's come by virtue of an amendment. So I would say that amendments would be a more effective way more than rules and regulations, because that would just be delegated legislation, and it is always a little harder when to decide what powers a court may have basically in rendering justice in terms of delegated legislation, whereas as opposed to a more effective means of basically statutory provisions, which can be easily enforceable, which can be easily invoked, and which can be easily adjudicated upon by courts. So, and also it becomes better if they come in the form of statutes, because then the ingredients are more specifically laid out. The law, I mean, in terms of rules and regulations, enforceability becomes a problem. It can be very vague. At least when it comes to criminal law, you have to be very specific. You have to ensure that, like, your two main things, as I mentioned, mens rea, actus reus, are always incorporated in it. Further than that, what comes in terms of ingredients, how they get satisfied. And obviously, I mean, it's very tough to draft criminal law. It's extremely difficult because you are dealing with, like, a lot of permutations and combinations. And even if one thing is left out from that permutation combination, it can be disastrous to the community at large, because you'll have criminals walking on the road. So it's very difficult, and I mean, it's not impossible, and it should be a good start right now, at least. And of course, there are courts to interpret it and, like, to construe it widely or narrowly, but I think it should be a good start to basically start amending and start, like, coming up with some sort of, even if there is delegated legislation which can then be incorporated into a particular new statute later or whatever, it's the time to basically start and tackle problems like cyberbullying, cyber stalking, all of this, because it's moving extremely fast, as I mentioned, which our laws may not be well equipped to protect.
Right. And the basic purpose behind criminal law is to eliminate the criminal mind rather than eliminating the criminal. So yeah, rightly said. We have talked enough of law till now, Yash, I think. Could you, like, you spoke of children using
From committing to others when the community at large from yeah.
Right. Okay, so Yash, throughout your conversation, you talked a lot about people being aware of things. People, children are using internet more nowadays as compared to when we were in school or when we started the college, right? So could you discuss some ways in which one can stay protected and advise a few measures that should be taken while using the internet so as to stay safe? This is something entirely not related to law. It's just we want to hear your thoughts.
So what you're asking me is, how do you equip yourself against bullying and stuff?
Right, exactly.
Is that what you're asking me?
Right.
To understand your question?
Right.
Yeah. So I mean, obviously, as I had mentioned, awareness against cyberbullying among various seminars, campaigns, like, on severe measures within universities also, that, like, could be taken, like, rustication, maybe suspension, or against all of the people who indulge in these activities. When I came to NYU also, there are very strict bullying laws, cyberbullying laws. So I think that should also be done effectively in India. What I would advise very importantly is any victim, any person who feels like, he is a victim to all these activities, they should keep the evidence alive. They should keep their WhatsApp messages. Under 65B of the Evidence Act also, we can basically get WhatsApp messages proved. So very importantly, it is, and it's something that these guys need to keep for proving and making the case, is keep all the evidence. I think there was an outbreak on LinkedIn also recently of a person who had started some small law firm, and there was an outrage by students because he was passing very inappropriate comments towards almost so many interns, right? And they kept all these WhatsApp messages alive, and then they were putting them all across the internet. So that was a good thing. I mean, if a person is being victim to these things, don't stay silent. Don't stay silent. You need to basically, obviously, put yourselves out there and make the person feel that this is what is happening. And the times are changing, like, right? People are, like, they are getting more. I mean, they're leaving all these stupid stereotypes behind, and, like, they're moving ahead. and people are going to be on your side. Like nobody wants to see a person being a victim to such nonsensical bullying. And put yourself out there. Don't stay silent. Don't be victim to this sort of. I mean, it's all in your hands. And sadly enough, what happens is across India there are several states where a lot of these things get subdued. Firstly, because I mean, it's just the tradition out there, unfortunately. Secondly, because people aren't aware about how to basically secure justice. Thirdly, because there is so much red tapeism, bureaucracy, corruption that is embedded, which unfortunately needs to be eradicated. And I think it's already in the process where it's begun. But I think it should move at an exponential pace right now, because this is what basically sets us back as a country. So in my opinion, it's not only setting guidelines, it's about implementation. It's about the institutions basically following those guidelines effectively. And there should be proper counseling, obviously, to the accused also. If suppose they're juveniles, they cannot behave in a particular way. So, I mean, for juveniles, there should be some sort of restorative justice mechanisms. I've studied this in London. Restorative justice is victim offender mediation. So they sit down and they basically have the victim and the offender face to face, understanding as to why you did a particular thing. Why did you basically do this to me? Understanding their mindset and properly mediating the matter. I don't know how effective it is. I've done a paper on it. It works in some cases, it doesn't. So my paper was just based on whether it works or not. And I showed them both sides of the coin. But in my opinion, in some cases, and not in heinous crimes, it's impossible to work in a heinous crime. But in certain matters like cyberbullying and everything, I think restorative justice could be a great way in solving the problem. So this is my opinion.
Right. So you spoke about the LinkedIn outbreaks that have been happening these days. We are witnessing a LinkedIn outbreak, I think every third or fourth day right now. But it started like 2 months back when a group of interns, got together and protest against some lawyers.
Yes.
But these are the new instances that are happening now. People are starting to turning up whatever wrong has happened with them. Before that, people used to stay suppressed, or feel that we should not open up because they are strong people and these things and all those. So and this impacts their mental health also in a negative way. Like
absolutely,
they get into depression at times. They they commit suicide. So do you think do you think that opening up can stop people from committing these kind of self harms, or and is there any legal protection for these people, like who are
yes,
victims to these crimes, and they end up committing suicide or landing into depression and these things?
Yes, absolutely. So section 306 of the IPC is concerned with the abetment of suicide. And now the larger question is whether it may or may not be brought against a bully if the victim commits suicide. Now, what 306 seeks to do is to punish those who obviously abet the commission of suicide or others. The parameters of this abetment are very important to look at. Unfortunately, we don't have much case law in India, but the parameters and I mean of abetment and what abetment actually has been enshrined under 107 of the IPC, which basically constitutes instigating. Instigating becomes it's a very important word in the definition. A person to commit an offense, or engaging in a conspiracy, or intentionally aiding a person to commit it. These are very strong words which need to be looked at and construed by courts in the widest manner possible. But I'll tell you what, it's also a very, very important, it's a very huge responsibility that has been cast upon a court. And whether, suppose you're in a judge's position and like a matter like this has come to you, what you look at obviously first is facts and circumstances. Now, if a person is constantly pinching a person, he knows that this guy's weak spot is this, but a person is constantly doing it to mess with his head. He knows this person is like, depressed, but you're doing it still despite him saying no. Then as a judge, what you would do. But also at the same time, this person may have other problems, family problems, which may have also been a cause of his depression. So in such a case, when there has been no doctor also to testify in such a case, because that particular person has just been keeping everything within him. it becomes very, very important for the judge to rule whether a person whether a person committed suicide because of this person bullying, or whether because of his problems at home. So there's a very thin line, because that, I mean, you can't put up, I mean, bullying happens, right? People I mean, it happens in some form or the other always. But now whether that would actually be the reason for a person to commit suicide, it's a very, very it's a very tough determination when it comes to a court of law. And this is why maybe the inadequacy of the law in this area, there may not be much case law. So what happens is that there is a dearth of convictions in the way section 306 has been interpreted by courts in India. Now, of course, there has to be firstly mens rea of the accused in such a case, which has caused him to incite or the deceased to have committed suicide in the first place. And that needs to be a very, very necessary existence for the application of 306. Now, obviously, what this implies is that it must be proved in court that the words "you don't deserve to live" have been uttered by the accused towards the victim. And because that is why the accused intended for the victim to commit suicide after listening to those words. So obviously, this is not going to happen. A person may not do it with the intention of making a person commit suicide. And it's very important to show this mens rea, which is why not many convictions are happening under 306 today. So, I mean, of course, practically it is very difficult to establish these facts in a court of law, because it casts a huge responsibility on a court to put such a person behind bars under abetment of suicide, which is a very, very heinous offense. Of course, he may come under the other sections of the IBC, may come under other sections, he may be booked under other sections of the IT Act, but under 306, it is an extremely delicate charge, and it needs to be handled and determined by the courts in a very strict fashion, because I mean, it's very difficult to establish intent for a person to commit suicide. Now, what if a person is already fragile, right? He's in school, his mind is not straight. Now, when you're a teenager, other people tend to basically take advantage of these situations. They'll obviously instigate and incite a person more. Whether courts should give more of importance to the words instigate, incite, and all these other matters, that becomes extremely difficult to ascertain for a court itself, and whether they should take it in the literal sense or not. So, as I said, there's a lot of gray area. It's a lot of responsibility on a court for booking them under 306. And I don't know if there is a need for a new perspective by the courts in such a situation, because, I mean, what essentially is instigation? What would constitute instigation? Certainty that it has led to this particular consequence. What basically now comes under a reasonable certainty, again, is a very factual and circumstantial scenario. Whether it is constant, like, constantly bothering a person, like you're doing it, there are constant taunts, there are constant, memes, this, that, wherein the deceased has found him completely hopeless and helpless to face such situations. So whether that could be an abetment or to suicide, I don't know. It becomes difficult, but yeah, it largely moves towards that. So I hope I have answered this question, but yeah.
Right. It is very difficult to determine what is going in the back of head of a criminal or a person who's committing these sort of things. But
I beg to differ when you just said this. I don't know if he was doing it with criminal intent. Right. He may just have been doing it. That's the problem. In the mens rea becomes very difficult to establish on a 306. Correct. Whether he was doing it with a criminal intent or not.
Someone might not have the intention to hurt the other person, but it ends up hurting that person, right?
He may have the intention to hurt a person, but he may not have the intention to basically make this person be pushed to a limit wherein he commits suicide, because this entire thing was under abetment to suicide. So, I mean, he's obviously doing it to hurt the person. So he'll be booked under other sections, and he probably will get a conviction order in the other sections. But whether it's to push a person to the limit wherein, he's so fragile. I mean, at a young age, you don't even think like, okay, my actions are going to push him to a point of like, committing suicide. So that's the whole thing. So it's again dependent upon a full factual scenario. What if an older person were doing this? What if somebody else were doing this? Then it's very circumstantial in my opinion. So
Right. So now I come to my last question. You in your previous answer also mentioned that teenagers are being victim to most of these crimes and are the ones who are committing these sort of things. So while you
who's that? Who's being victims to the crime?
the teenagers you had mentioned.
Teenagers, yeah, teenagers.
So while I was talking to my friends about this podcast that I'm going to record, so basically we have a team of 25, 30 editors and content writers that work for our content platform. So I was talking
Wow,
to them that what kind of questions I can come up with, what can I do and ask the person, the guest. So one of my friends who's editor also with us, who's an editor also with us, she told me that when she was in school, one of the classmates, he just had downloaded a picture from a social media account and had posted it on his social media account, and has put some funny caption or like someone that could hurt her. So if so she basically asked me to put this question in front of you, that if a woman's photos are taken from their social media account and put elsewhere without their consent, what can be the best
yes.
possible recourse?
I mean, you have several sections under the IPC, under the IT Act also. I think I just mentioned the section because I think 66E, because this is also a breach of privacy, right? So it comes under all of these particular acts. Yeah, 66E deals with the punishment for the violation of privacy. 67B also is the punishment for publishing or transmitting material. So she could basically move under these sections. And of course, there are 354C, a cyber for taking pictures and for transmitting. Sorry, for if he transmits or publishes the same. And also, I mean, the caption could come under defamatory messages of 500 of the IPC. So redress is there to answer a question.
Right. So one more thing that has come to my mind is that when we post something on social media, there are people who like it, people who share it, people who comment on it. So if someone likes, comments, or shares on some defamatory post about someone, do they also become a party to defamation? Do they also become a party to cyberbullying?
I think liking it, I mean, it really depends. I mean, even if you move against these people in a court of law, see, I mean, it's also about wasting money and resources.
Sorry to interrupt, but when you like a picture, when you share a picture, it goes on your profile also, and your connections also can see it. Like if on Twitter you
Right.
like something, then your connections can
Right.
see that this person has liked this picture, and it
Exactly.
goes to most of the audience. So
I mean, it gets shared and people. Sorry, I have a bad cough. But what's happening is that when they're sharing this, I know that's why I've been telling you that the lawmakers need to understand that what is happening in terms of AI, why this post basically then gets shared on so many different pages. It comes up everywhere, right? So then they have to come out with some rules wherein whether this is abetment to that particular crime, whether liking it, or if comments for sure, like if you comment on it and you further instigate the post in itself, and like you passed a derogatory remark in a comment, of course, then that becomes a problem. If I'm suing, suppose I'm a victim of these things, would I sue a person who has liked my post? I can ignore them. I can cut them out of my life. I don't know these people also who like them. But who will I sue first? The person who puts the post up primarily. Second is if there's any derogatory remark that has been passed, of course, I'll sue that person also. So it's all about like, also when you're suing, you have to understand who you basically want to make as your as the accused in your particular case. And if you really think that there is a person that who's liked it, and like you have some you have some vendetta or something against this person, you can sue. But then again, like he'll just be for the court to basically understand whether liking a particular picture may also basically be an abetment to this sort of defamation or this sort of activity, then that's also incumbent upon courts to decide depending on the facts and circumstances, of course. But in my opinion, liking a picture would not have so much of a consequence as much as posting it, of course, putting up an inappropriate caption and passing inappropriate comments on it, and further inciting other people to basically like it. So yeah, that would be my answer in this case.
Right. So you have thrown some, you have shed some good light on all these topics, ranging from the sections, awareness programs that could be run. People should speak up, and then this abetment to suicide and intersection of IPC and IT Act and all these things. I think our listeners will find this podcast very informative, and I thank you on behalf of whole TLJT for coming and recording with us. We look forward to host you in future also. Thanks for coming.
Thank you so much, Ariman. Thank you for having me. It's been a pleasure, and I hope I could provide some insight on this topic. And yeah, hope to connect with you soon. Congratulations again, and I hope you all do really well.
Thanks a lot.